Stand by SOT1.
Standing.
10 seconds. Ready, rollin'. Ready, SOT1.
Ready.
In 4, 3, 2, 1. Roll in.
From legendary Uncle Studios in beautiful Southern California, welcome to another edition of Work Comp Matters, the central location for you employees, you employers, and of course, we haven't forgotten about you damn independent contractors. And now, here's this week's edition of Work Comp Matters. 12:01 straight up on June 15th, 2020. Welcome to another edition of Work Comp Matters. We are, of course, brought to you by the workcompcentral.com. If you want the number one location for workers' compensation in California and around the United States, check out the workcompcentral.com. They've got a free 7-day offer. And if you want to pick up their services, I have them. You should too. It's only $1 a day. Work Comp Matters is also brought to you by A1 Law, number one computer management system, 818-357-4120 for your no strings attached money back guarantee. Also, $1 a day, A1 Law. Well, good afternoon, everybody. Welcome to another edition of Work Comp Matters. I am, as usual, joined by my chief of staff, who keeps me in check and hopefully out of trouble at least 90% of the time, the doctor, but he's not a medical doctor, Mike Zima, and the madman across the water, 35, 40-year retired California workers' compensation attorney, Mr. John Scalia. Well, major blowback to me for not wearing a mask at a deposition. We're going to talk about that later. But the story of the day, the United States Supreme Court delivered a watershed victory for LGBT rights, ruling that a landmark federal law forbidding workplace discrimination protects gay and transgender employees. The 6-3 ruling represented the biggest moment for LGBT rights in the United States since the Supreme Court legalized same-sex marriage nationwide in 2015. In the new ruling, the justices decided that gay and transgender people are protected under Title VII of the Civil Rights Act of 1964, which bars employers from discriminating against employees on the basis of sex, as well as race, color, national origin, and religion. I want to go to John Scalia for a moment. John, I thought that California, at least, had already had protections under Title VII or Title IX for sexual orientation. And I'm not sure if I'm right. What do you think?
I don't know. I should have Googled it after we talked, but states can, of course, have their own anti-discrimination laws, but it wouldn't have been.
I'm pretty sure we had our own statute.
Yeah, that may be. Yeah.
But other states didn't.
Pardon?
Other states did not.
Right, exactly. And certainly under the federal law, it hadn't been decided yet, obviously.
Correct.
Or the Supreme Court decision wouldn't have been made.
Because whenever anybody asks me about discrimination, I always just naturally associated sexual orientation with whether or not you're a man or a woman. But hey, I guess Steve Appell is ahead of the times. Workplace bias against gay and transgender employees has remained legal in much of the country, with 28 of the states lacking comprehensive measures against employment discrimination. The rulings in 2 gay rights cases from Georgia and New York and a transgender rights case from Michigan recognize new worker protections in federal law. The ruling was authorized by conservative Justice Neil Gorsuch, who was appointed by President Donald Trump in 2017. Chief Justice John Roberts, another conservative, along with the court's 4 liberal justices, joined Gorsuch's opinion. Conservative justices Samuel Alito, Clarence Thomas, and Brett Kavanaugh dissented from the ruling. Well, guys, I think that if this has not been law, it should have been law a long time ago.
Well, that's, of course, I think the way most sane people think. In other words, I was surprised that it wasn't the law of the land, okay? And I don't care how they got there. I'm just glad that they got it right.
Yeah, and I think it's a good indication that Alito, Kavanaugh, and Thomas, who I prefer to call Uncle Thomas, are lost causes. I mean, they're hopeless. And
I am working with a new microphone as well as a new headphones. And Scott Walton of Uncle Studios just send me a text whether or not Mike's voice is bleeding in. I'm somewhat hearing it on the headphones, but just send me a text saying it is a problem or it's no problem. Our second story, and we're going to get to me being blasted on Facebook for not wearing a mask at a depot. I know all of you want to talk about that, but here we go. Second story, you all may remember the issue with Governor Newsom purchasing 100 million masks from Blue Flame Medical, that whole debacle. Well, Blue Flame Medical, a medical supply and healthcare logistics company, filed a lawsuit today against Chain Bridge Bank in Chain Bridge Bank and 2 of its senior officers in the United States District Court for the Eastern District of Virginia. The complaint alleges that the bad acts of the bank in violation of federal banking regulations led the state of California to suddenly breach a law contract with Blue Flame, which set in motion a chain of events that left the reputations of Blue Flame Medical and its founders, John Thomas and Michael Gula, destroyed. I would like to invite Dr. Mike Zima and John Scalia to give us a, "Oh, war's pitiful me. We feel really sorry for John Thomas and Michael Gula." Okay? After receiving an order for 100 million N95 masks from the state of California, Blue Flame Medical needed to receive an upfront deposit via wire transfer of more than $450 million from California so it could secure the production of the state's order of masks. And we've talked on the show before how I don't remember ever that the state of California wired almost $500 million to any company whatsoever. Having had the long-term relationship with Chain Bridge, Blue Flame's co-founder Michael Gula approached bank executives on March 24th about the transaction and was repeatedly assured by the bank's president and chief executive officer not only that the bank could handle the transaction, but the bank was enthusiastic about it. Then on March 26th, the bank confirmed that the wire from California was received, accepted, and the money was there for Blue Flame to use. However, the bank's executives suddenly decided to have the wire deposits sent back and suggested to California officials that the transaction and Blue Flame were fraudulent. Then unilaterally and without warning, in violation of federal banking regulations, the bank removed the funds from and closed Blue Flame's account. I find this story fascinating and continually developing. Do you guys have any thoughts, questions, comments, or opinions?
Well, there certainly seems to be a lot that we don't know. I mean, why would the bank do that? John, why do you think the bank would do that?
I have the same question. And I would think either it's because the guy at the bank realized it was such a large transaction, he needed authorization from his superiors and he couldn't get it, or they got some, or they went to somebody else, maybe outside counsel, and they said, you better make, damn sure that this is legitimate. I mean, yeah, it seems like there had to be some sort of outside intervention at that point.
And again, just going back to when we first reported this, Gavin, the state legislature went on vacation and gave Gavin Newsom a blank check for any COVID-19 emergencies of up to $1 billion. Well, what does Newsom do? He spends the whole friggin' thing on masks. And by the way, Mike, I don't think we've seen mask one from any of these transactions yet, have we?
Well, I guess they canceled the transaction, so I guess we have not.
There were a couple of transactions made.
Didn't they offer to give you one at your depot?
And John, thank you so much for reminding me. We're going to talk about that in the second half of the show. My name is Steve Appell. You're dialed into WorkCompMatters. We are brought to you by the workcompcentral.com. If you want the number one location for workers' compensation in both California and around the United States, check out the workcompcentral.com. They've got a free 7-day offer. And if you want to pick up their services, I have them. You should too. It's only $1 a day. WorkCompMatters is also brought to you by A1 Law, number one computer management system, 818-357-4120. Mike, I'm hopeful that you have a story on Mr. Robert Fuller, but if not, go ahead. What's your first story of the day?
Well, I don't have a story on Mr. Robert Fuller, but we can certainly talk about it. But I'd rather get this COVID story out of the way first, if you don't mind.
Sure, go ahead. And again, just a short message to Scott while Mike is talking. Send me a text and let me know if there's any feedback because we're using a new microphone system. But Mike, go for it.
With all the businesses that are opening back up in some California counties, bars, gyms, and movie theaters, to name a few, it can be easy to lose track of just what stage of reopening California as a whole is in. Officially, California is still in stage 2 of reopening from the shutdown prompted by the coronavirus pandemic. Some counties have permission to move ahead quickly through stage 2. Quote, there is not yet a timeline for moving to stage 3 statewide. California is currently in stage 2, and counties with attestations are able to open some activities and businesses under stage 3 by following the guidance issued by the state, end quote, according to a statement from the California Department of Public Health.
And
Steve, have you noticed that things look like they're opening up? Have you noticed that?
There's no question about it that the state is starting to open up, as I've advocated all along. And I've said that, in my opinion, there's no reason why any businesses right now should be closed. Every single legal business in California should be allowed to reopen as long as they're practicing social distance guidelines. John Scalia, what's your take?
Well, again, I would go with the medical experts. When they say it's safe, it's safe. And, until then, no. So I don't know what they're saying right now, but I would just base my opinion and advice on what the medical epidemiologists say.
And since you bring up what's safe and what's not, as we all know, I attended my first deposition in 3 months at a defense attorney's office last week. And when I walked up to the office, there was a sign outside that said, quote, "Out of an abundance of caution, please practice social distancing guidelines of at least 6 feet," close quote. There was nothing on the sign about the mask. So I walked in and we went to the conference room. Conference room is, say, about 12 feet by 16, 12 feet by 18 feet. They had a standard conference room desk. I want to say it's about 8 feet long, 3 feet wide. Defense attorney came in. He was masked. I was sitting next to my client. He was masked. Court reporter was there. She was masked. I chose not to wear my mask, which of course I brought in. And if the sign said, "Please wear a mask," I would have put it on. If someone had said something to me, I would have put it on. If the defense attorney said, "Put on your mask or else I'm canceling the deposition and we're going to file for cost and sanctions," or whatever, I would have put it on. But nobody said word one. So I kept my mask off for the entire deposition. I posted this on Facebook, not as a reform as to whether or not it's okay to wear a mask, not asking for comments whether or not to wear a mask, but just as an accurate recall of what happened, and specifically that no one said anything. And I was blasted on social media. Basically, in so many words, I was accused of being the Grim Reaper and one of the contributing causes for more death, not only in Southern California, all of California, but the entire country, the United States of America. And I've discussed this with both of you before, and I wanted to get your takes. Go ahead. I never tell you guys what to say and what not to say. Michael Zyma, what do you think about me not wearing a mask at the depot?
Well, I'd like to talk about the reaction, actually. It sounds like what the people, and I assume this is on Facebook, the people, they put you in a basket. They put you in the perhaps the Ted Nugent basket. They put you in the basket, not of deplorables, but they put you in the basket of perhaps the deniers, the naysayers, something like that. That's the impression I got. Now, as far as a mask, frankly, I probably would have done exactly the same thing you did. I probably maybe would have even forgot to put it on because they're uncomfortable and depots are long. But if they had said, "Hey, put your mask on it would have gone. That's what I think. John, what do you think?
Well, to begin with, let me say that a long time ago, well, even to this day, I ski without a helmet, okay? And helmets are not required. And I posted something years ago when I was skiing in Europe about the fact that I was amazed to see why all these people were wearing helmets. And I got blasted on social media. It was on Facebook. I got blasted about, not wearing a helmet, even though clearly it wasn't required. So people react very strangely to that. As a personal incident, I think that you probably should have worn your mask out of being polite. And I do think that your Facebook post tended to come off as being a little bit of bragging about not wearing the mask, and that may have also prompted some of the reaction. But as I said, I think if you're in a confined space for a protracted period of time with strangers, you probably should wear a mask. But somebody should have asked you to please put your mask on, and asked very nicely. So that's my take on it.
And I would have immediately put the mask on. Mike Zima, do you have another news story for us?
Well, I'd like to get into the events of the weekend if we could.
Please do. Please do.
Okay, so I'm sitting there watching a cop shoot a black man in the back.
And this is in Atlanta.
In Atlanta, Georgia. And gosh darn it, folks, for the life of me, I can't understand how a police officer can feel licensed to shoot somebody in the back when he doesn't have to. And yes, the guy was probably toasted. The guy was probably drunk as could be. Yes, I understand that. And yes, he had the cop's stun gun and all that kind of stuff. But you just don't shoot somebody in the back. I don't get that. For the life of me, I can't understand that. And then in the Antelope Valley, we have two situations where two black young men were found hanging from trees. Now, the coroners have said that it looks like it was suicide in both instances, but the families are not buying that. And they're trying to get a bigger investigation, a statewide investigation, trying to escalate it to the state. And I think that's, of course, what should be done. But gosh, guys, I mean, it seems with every weekend we're getting closer to helter-skelter. John, what do you think?
Well, I was going to do a segment on cops and their PR thing about every day we put our life on the line for you, and point out that, in point of fact, the Bureau of Labor Statistics keeps a record of which jobs in America are the most dangerous to your health on the job. And being a police officer isn't even in the top 10. Okay. You can look it up. You can Google it. So it's just police PR. Yeah. The guy was running. Actually, he was running pretty well. I think maybe the cop was too embarrassed to admit he couldn't catch him. I don't know. So he shot. Yeah, I saw it. He shot him in the back. The guy had his taser. But, when the cops use a taser, they're constantly pointing out tasers aren't life-threatening. So clearly,
correct,
it was an excessive use of force, even with that. And he was
John,
running away.
John, I'm aware that the tasers, when used as is supposed to be used, are not deadly. But
Right.
Can they be used so they can be deadly?
I think if you repeatedly taser somebody with it, yeah. But this guy was running. He was running away from the cops. So theoretically, he would be shooting the taser over his shoulder. And he'd have to be pretty damn good and not drunk to be able to do that. Although I have to admit, when I saw the guy running, he was running pretty well for a drunk.
And I'm not advocating either position. I'm just trying to further explore what happened and what could have happened.
Well, there's no question that the use of lethal force was totally unnecessary. I mean, any reasonable person looking at it would say, let me get this straight. The guy was asleep in his car to begin with. You understand how he got pulled over? He didn't get pulled over. He fell asleep in the drive-through lane of a fast food restaurant.
Yes.
And so they pulled him out of his car and they gave him a sobriety test, said you flunked the sobriety test. And then he grabbed a taser and started to run away.
Well, actually, no. What happened was I saw this video. They had been speaking to him, I think, for about 20 minutes. This was at the initial stop. This is when another officer was called in. They then had him do the test of like touching your fingers to your nose, walking forward and back.
Yeah, it's a very unscientific test, and it's designed so you fail it anyway. You probably couldn't pass it right now, Steve. But anyway, go ahead.
No, I'm just doing my best to accurately report what happened.
Agreed.
Okay, so after they put him through the test and they asked him, I think, if he would take a breathalyzer, and he refused, I think, they then
he took a breathalyzer.
Okay, so they did the touch your fingers to your nose, walk forward, walk backward. They did the breathalyzer. Then after about 20 minutes or so, they said, okay, sir, we are now going to handcuff you. And in the process of being handcuffed is when he started to resist arrest. And then that's when the whole violent situation started.
There was no violence. I mean, he took the cop's taser and he ran away. That's not violence.
No,
they were
actually, hold on, Mike, hold on a second. John, that's not true. They were rolling on the ground for about 2 minutes before he grabbed the taser and started to run away.
Well, I assume when a suspect's on the ground, that's probably not the suspect being violent.
John, it was the two of the officers, as Mike said, grappling with him on the ground for about 2 minutes before he took the taser, got up, and started to run away.
Okay.
Just telling you what I saw.
I don't see, you understand, in California, resisting arrest, the legal definition of resisting arrest in California is simply doing anything which other than simply going meekly with the officer. Any other act is legally resisting arrest. So, no doubt he was probably resisting arrest. But the question is, even assuming that your description's accurate, I hardly call that violence. I mean,
John, you're absolutely right. I should have said rather than violence, that he was resisting arrest for 2 to 3 minutes. I should have said that. You're right.
Okay. And how two cops who are sober can't get a drunken suspect in cuffs in 2 to 3 minutes. I guess that goes to whether or not they have adequate police training. But that's kind of surprising too, isn't it?
Mike, would you agree that my verbal representation of what happened is relatively accurate as to what you saw on the film?
I'd still use the word violent.
Oh, okay.
They were going at it. But let me ask John a question.
But did you see the suspect hit the cop at all?
He was
no,
on.
I want Mike use Mike City say violent.
And
answer the question. Did you see the suspect
we've got about 2 minutes left. So Mike, Go ahead and answer.
It's a yes or no question. Did you see him hit the cop?
No. You're right, John. I didn't see him strike the officers with his fist.
Yeah,
I didn't.
Right.
I saw them wrestling.
Well, yeah.
Which is what I saw. I saw wrestling. I did not see a punch thrown, but then again, I only saw it one time.
But that just means he needs to be restrained. When you've got two cops who can't restrain a drunken suspect, even on the ground, to me, that's astounding.
Well, that's true. And before we go, if I could ask John one more question. John, talking about the state of mind of the officer who fired the shots into the guy's back, okay? After he shot the guy and the guy went down, he said, quote, "I got him," end quote. Right. Well, do you think that has any relevance as to his state of mind?
Oh, yeah. Sure.
And I think that's a good time to end the show. I want to thank you all very much for listening to today's Work Comp Matters, June 15th, 2020. For my right-hand man, Dr. Mike Zyma, for the madman across the water, John Scalia, for Scott Walton at Uncle Studios, and all the good people back at WorkCompCentral that continue to support and approve of this valuable project, including, but not limited to, Ms. Kristen Chavez. My name is Steve Appell. We'll see you again tomorrow at 12 noon for another edition of Work Comp Matters.